Today on Fox 11, we will be giving you information on Roger B. Taney, but first, breaking news. It is the year 1971, during the Vietnam War. The New York Times and the Washington Post have illegally leaked classified documents about America's involvement in the war. And so it has begun, a First Amendment battle between the highest levels of government and the two most known newspaper companies in the country. We have gotten word that Daniel Ellsberg is the one that decided that these papers need to go public. He has made about 7,000 copies of this document that reveal the history of the government's actions in the Vietnam War. Government officials have quickly gotten a court order that will prevent the New York Times from printing any more of these documents, arguing that publishing this material has threatened national security. Yes, there was a slight bump in the road. However, this did not stop Ellsberg. He then released the Pentagon Papers to the Washington Post. This time, the government could not get a court order. In the next 2 weeks, the case of the New York Times versus the United States ended up in the Supreme Court. The government has told us that the war is coming to an end. However, the Pentagon Papers say differently. Can we really trust our government? What can we do to stop these lies? Well, these questions will be answered after the break.
You can get a ton of new food for cheap. Try my 10-piece chicken nugget combo. 10 of my crispy all-white meat chicken nuggets plus fries and a drink for only $3.99. You're welcome.
And we're back. The New York Times was accused of breaking the Espionage Act. The Espionage Act, for those who don't know, prohibits any form of speech that is disloyal, profane, or abusive towards the government of the United States. Overhearing this case is Chief Justice Warren E. Burger, and the attorneys defending the New York Times are Alexander Bickel and Floyd Abrams. They argued that the Espionage Act is very broad and that the New York Times was just practicing their right to freedom of speech and freedom of press. The court faced a difficult decision regarding the First Amendment and to what extent the constitutional right should be implemented. Over time, it was decided, 6-3 in favor of the New York Times and the Washington Post. The court would grant the decision to the New York Times and the Washington Post, stating that they were just exercising their First Amendment right. What was argued on June 26, 1971, was later decided on June 30th, 1971. It took 4 days to make a decision on a case that changed America for the better.
And now Roger Taney's early life and career. Roger Brooke Taney was born in Calvert County, Maryland on March 17, 1777. He grew up on a successful tobacco selling company that ran in his family of 8. Instead of inheriting land by his family, Taney wanted to continue his education in college and practice law. In 1806, he married Anne Key, and a fun fact was that Anne Key was the sister of Francis Scott Key, who wrote the Star-Spangled Banner. To begin with, Taney was first a member of the Federalist Party until 1812, when the party opposed the war against England. Continuing his career as now a political maverick, Taney was elected to the state senate. Since many juries were impressed with Taney's fair play and courtesy towards opposing attorneys, he was appointed Attorney General of Maryland in 1827. By this time, the Democratic leader Andrew Jackson recognized his cabinet in 1831 and appointed Taney Attorney General of the United States. Some important key facts to remember here is that Taney was rejected by the Senate in 1833 due to his controversy with the fight against the Bank of the United States. Taney had now become a national figure, and this marked the first time that Congress had refused to confirm a presidential nominee for a cabinet position. Although Taney's career took a turn, he continued rebuilding his practice in law and soon became Chief Justice of the United States in 1835. When hearing about Roger Taney, he is most known for his opinion in the Dred Scott v. Sanford case. Here, he believed slaves were not citizens of the United States and therefore could not sue in a federal court. These segregated opinions led to the Northern press getting bitterly attacked, and this decision probably created more disagreement than any other legal opinion in U.S. history. Lastly, Roger Taney died in 1864, although he had an enduring influence on the evolution of the United States constitutional law. This concludes our presentation. Thank you.